In this journey of Beyond Law CLC, we have done various sessions, and I can say with some sense of proud to the effect that Justice Roshan Dalvi has been one of the foundations and the backbone for this journey of Beyond Law, where we have done various sessions. And today's session is also quite fascinating and in tune with what normally the youngsters who have joined the law institutes and schools do ask, that is commercial law practice, the interplay of Commercial Courts Act with CPC, Arbitration and Mediation. This 1 hour journey with Justice Roshan Dalvi, as usual, I'm quite sure, would always be an treat for the ears as well as the eyes. Over to you, ma'am. Yeah.
Good evening, Vikas, and good evening, friends. It is good to know that we are talking about commercial law practice today. You see, we always have certain statutes, the object and purpose of which will have to be understood. Prior to 2015, when the Commercial Courts Act was enacted, the position of commercial cases in large metropolises like Bombay was very precarious. Suits were not reaching hearing. It was bad for our global image. It was in those circumstances that this act came to be enacted. Along with this act, the CPC came to be enacted. And it shows what we were lacking at that time and therefore how we can improve after that time. It's been now 10 years of this act. It is for each one of us to find out whether there is any, and if so, how much improvement in the image of the adjudication, arbitration, and even mediation now in commercial law practice. Now, first, friends, the object and purpose of the CCA. One was, as we have seen, read it in the Act, speedy disposal of commercial disputes. That was because they were not speedily disposed of. Independent mechanism for early resolution. Creating an image to the investor world of an independent, responsive Indian legal system. Improve efficiency and reduce delays to accelerate economic growth. So, friends, everything points to the fact that there have been delays and there have been catastrophic delays, and that must be removed if the image has to improve. Okay? So we have got 3 types of commercial courts. Commercial courts in the district under Section 3, commercial division in the High Court under Section 4, and commercial appellate division for appeals in the High Court, which is analogous to appeals on the original side. Okay? Having these 3 courts set up, it is expected that the commercial disputes will go as per Section 16 of the Act, which shows the amendments to the CPC so that the procedure becomes more amenable to less delays. Okay? Now, one of the main sort of aspects of this was that under Section 8, there is no revision against interim order or any jurisdiction order. This is analogous to the Arbitration Act under Section 16 and any other applications and awards which are passed under the Arbitration Act also. So there is a similar jurisdiction for arbitrations under Section 10 of the CCA. So we have to read the commercial courts for the commercial causes in adjudication as well as in arbitration. And then after 23 and much after 2015 when the Commercial Causes Act came, and thereafter in the amendment, the mediations came, also the mediations. Okay. Now, which are the commercial transactions? Which transactions would be covered under this Act? This is not under the CCA. It is under Explanation 2 to Section 34 of the CPC. Commercial transactions are defined as transactions connected with industry, trade, and business of the party incurring the liability. The party suing may not be in the same business, but the party incurring the liability, if it is in any industry, trade, or business, it becomes a commercial transaction. Okay. Now, Section 34 deals with interest. So it shows how the interest could be charged by the party who sues upon the party who is incurring the liability. Now, this would be in money claims, in all agreements between parties, and in immovable properties. So everything is covered under what are called commercial transactions. Aside from this, under the CCA, commercial disputes are defined in Section 2. It gives us some list of 22 disputes, 22 kinds of transactions and disputes therein. But the main ones are the financial transactions, all kinds of financial transactions. You can say maritime, you can say insurance, any of those financial transactions. Disputes between traders, which also would be anyone in the trade field, admiralty suits, construction contracts, and all of these in arbitration. The extent of jurisdiction of commercial courts at the time it was enacted 10 years ago was 1 crore. It rose to 3 crore, now it is 10 crore. It is the specified value under Section 12, and by way of notifications, it keeps increasing. So, any suit, any arbitration of that value or more in a commercial transaction with a commercial dispute would fall within the commercial court's jurisdiction or the arbitration as a commercial cause. Okay. Now, this would be, how do you find out this? So, this would be for recovery of money, 10 crores and above, market value of movable property. There are not many arbitrations and adjudications for movable property. But market value of immovable property is important because all the construction contracts and all the contracts with in real estate would be covered in that, and market value of any intangible right. So aside from the contracts which give specified figures, which would be recovery of money, there could be various other reliefs claimed in adjudication as well as arbitration, depending upon the intangible right which is created. It may be of possession, it may be of declaration, injunctions, etc. Now, the features of the Commercial Courts Act must be first understood. Pre-institution mediation is under Section 12A in an amendment that has come. Now, this has caused a lot of complication because the defendants in the suits and the respondents in the arbitration would not be amenable to mediation, though wrongly. It is a wrong perception that a very good attempt at mediation should not be made so that you can delay the payment. But then the payment comes with interest, and under the Arbitration Act, 2% more than the bank rate of interest. So it doesn't stand to reason, but somehow the advocates, lawyers, pleaders who are for the defendants and respondents do not respond to this very good provision. This requires negotiations between the parties. Now, there may be a lot that respondents or the defendants in the suit would have to say why this has come about, how it could be overturned, how it could be taken care of by both the parties, and that cannot be done in adjudication or arbitration. It can be done only in mediation. So when the mediation culture becomes ripe and fine, then this section becomes a trademark for the CCA. The pre-institution mediation today is only with consent of both the parties. The defendants do not consent. It is also if there is no interim relief asked for. But as soon as an interim relief is asked for, it is taken that now there can be no mediation. It's a very wrong approach. When there is an interim application, be it in arbitration or be it in adjudication, it is pending, and therefore that has to be first considered so that some modicum of relief can be granted to the party who deserves it. That is the purpose of saying that if there is an interim application, then there can be no mediation because otherwise they may go on wasting time and the interim relief cannot be granted and it may become irreversible. But after the interim relief is granted, either by way of an interim relief application or a notice of motion, as we call it in Bombay, or under Section 17 of the Arbitration Act, when the arbitrator grants interim relief, once it is granted, there is no interim application. So, when there is no interim application in a suit at any stage, instituted mediation can take place. Now, this has been working extremely well in Canada. In Canada, the computer system itself, after the interim application is over, takes you on to the mediation panel. So it is not that one party craves for or asks for mediation and another party refuses. Both parties just have to go there and give it a good chance. And that has worked. And that is because it is instituted in the system itself. This we still don't have. Now, appeals, as in Order 43 of the CPC and Section 37 of the Arbitration Act, are under Section 13. So, when you go from an interim relief application under Section 17 of the Arbitration Act or in an order of the notice of motion, the appeals go to the Commercial Appellate Division. Now, actually, the mainstay of this act is the amendment of the CPC under Section 13. And those are vast amendments. Some of them are of day-to-day use in commercial causes as well as in arbitrations, which we will deal with separately because it needs a thorough lookup. But there is also statistical data maintenance. How are the courts faring? How are the arbitrations faring? How much are disposed of and how much time is actually now under a statutory obligation required to be maintained and can be asked for by any litigant. High Court practice directions under Section 18 is another important thing, that whenever you find any roadblock, the High Court can pass a practice direction. Now, for example, I may tell you that in commercial causes and in commercial disputes in arbitration, we require sometimes independent witnesses. These witnesses may not be brought by the party just by telling them to come. Therefore, summons have to be issued. And an application has to be made first to the arbitrator that this is required. And then when the arbitrator says, yes, this application would be required because this witness would have to be examined, you make an application to the High Court. And the High Court is flooded with Section 27 applications. Now, this is a kind of a clerical work. As a trial judge of 27 years, I must have issued at least 2,000 summonses. And it took me 1.5 minutes because I knew what the matter is about. I knew who is the witness. The parties would get the summons prepared, and all that had to be done was to say, issue witness summons as prayed for, returnable on so and so date. This has not happened, and High Court practice directions for this would be very much welcome. There are some other things also, but this is actually going on all the time from this. Now, one more thing that we can say is in arbitration of commercial causes, under Section 29A, period has to be extended. Now, this is also not much of a judicial work, though, of course, it requires application of mind because when there is an obligation to grant, there is an implicit power to refuse to grant by a court. And when a High Court judge has to do that work, it has to be done that way. It is not done, and extensions are granted again and again by different judges that come up in different assignments and who do not know what has happened earlier. So, High Court practice directions, even for this, would be very much welcome. Then under Section 19 of the CCA, we have infrastructure facilities which are required. One of the facilities, of course, is the making of the court itself. But the other infrastructure facilities would be online adjudication or online arbitration, seeing the national grid and finding out what is the stage, etc., etc. Then training and continuous education under Section 20 is one of the first new things which have come up in our Indian legislations, which has been there in America, England, Canada for a good number of decades. And that kind of training is always required for all stakeholders, be they judges, arbitrators, lawyers who appear in arbitration, and even witnesses at times. And different training programs would be there. They are now there under the Arbitration Act. They can be there. They are there also for the judges in our national and state judicial academies. And that is the continuous education we must go on having. So these are the special features of this act which are not in other legislations. Therefore, friends, the ambit of the commercial courts is in two ways. One is procedural and one is substantive. And that requires two things, infrastructure and sensitivity. Now, infrastructure is what the government can give us, sensitivity is what we have within us. Lawyers as well as judges working as a team and working to do good for all the litigants as per, you can say, the obligations and responsibilities of these stakeholders would be the ultimate sensitivity. But friends, what we must understand is what are the CPC amendments under Schedule 1 in Section 17. So Schedule 1 of the CCA in 2016 says, Section 35, it grants actual costs of the fees incurred in arbitrations in the suits, actual cost of the expenses incurred for witnesses, for lawyers, etc. They all can be given to the party who wins. Generally, it is the party who wins, except if the judge or the arbitrator says otherwise. Then under orders, so Order 5, Rule 1, the written statement cannot be after 120 days. Now, this should be a sacrosanct limit. Unless that is made sacrosanct, there are many delays that come up, and this must be read along with the section in the Arbitration Act, which gives 6 months for the claim and SOD, then the counterclaim and the reply to the counterclaim. All of this to be done in 120 days. Then under Section 7, Rule 2A are the interest details. The claimant or the plaintiff in a commercial cause must give the various interest details that the claimant requires to have. That is from which date to which date, why interest, how much interest, commercial rates, etc., etc. Under Order 8, Rule 1, written statement within 120 days. This is as good as Order 5, Rule 1, which talks of the plain and the written statement. Order 8, Rule 3A is very important and much sort of ignored in most arbitrations as well as in suits. Denials with reasons. We have, at least in Bombay, I'm talking about the Bombay jurisdiction, we have a great itch of saying that I am admitting the receipt of the email but not the contents. Now, this means nothing. The emails which come, the letters which were coming earlier, now they are emails, come as a link from one to another. They are a chain of correspondence. They have to be taken and read together as a chain of correspondence. And denials, merely stating that they are denials, have to be ignored by the adjudicating authority. And those documents, including those emails, have to be just brought on record and considered. So there has to be marking of those documents and then appreciation of that documentary evidence. Now, Order 11, which was much not used earlier, has got a lot to do in the commercial causes after the CCA. Order 11, Rule 1, Sub-Rule 4 is the disclosure. The disclosure of documents must be in the pleadings itself, plus 30 days. So if you have not made it in the pleadings and you've said that you will crave leave to refer to and rely upon those documents, within 30 days, they must be shown to the other side. And this shows that those kind of directions are now not required to be passed. Those directions are passed in the legislation itself. And it has to be within that time period. And if it is really enforced, then, step by step, it would be streamlining the procedures. Order 11, Rule 2 are the interrogatories. The interrogatories are before the cross-examination if you want certain details, and if it is going to take up more time, you'd rather ignore the interrogatories but go through the evidence. Then Order 11, Rule 3 is the inspection of documents. So the disclosure has to be made in the pleadings plus 30 days. And inspection has to be within those 30 days plus at the most another 30 days. If the inspection is not offered, then that document cannot be relied upon. This actually is not really for the agreement between the parties, which is an admitted document invariably, the main agreement on which the suit is filed or the arbitration proceeds, and the various emails that come up, but it would apply to the documents which are of independent witnesses, which would have to be proved through independent witnesses. And if they are to be proved, then they have to be offered for inspection within 30 days. Then Order 11, Rule 4 is very interesting. Admissions and denials within 15 days with reasons for denials on affidavit. So if an affidavit is filed and a statement is given, admissions, denials, this is admitted, this is contents are not admitted, it has to be actually ignored under the law today. Okay? It has to be actually brought on record and then considered, of course. Then costs for undue denials. So simply at all, I deny has not to be said now under the new culture for commercial courts. And that culture is now 10 years old, and I don't know in how many matters it is followed. So costs can be granted if unduly any document is denied, and then that document has to be marked. Order on admitted documents is also under the same Order 11, Rule 4, that whatever are the admitted, this is for denials. So whatever are the admitted documents, including waiver of proof, etc., rejection of documents, all those can be considered at that stage after the pleadings are filed, and admitted documents can be marked. Then Order 11, Rule 5, production of documents within 7 to 15 days. If documents are not produced, and if the other party wants production of the documents and gives notice to produce, they have to be produced within 7 to 15 days, and otherwise adverse inference has to be drawn. So it's very simple, and it is very good for streamlining the procedures that you have to show all the documents. Order 11, Rule 6 are electronic records. They have to be proved by the printouts. So by and large, all electronic records are not fabricated. They are all fine. And therefore, all those can be taken by way of printouts. But if suppose there is anything where you find that there is any kind of fraud or any kind of fabrication, then that has to be proved by the other side that there is a fraud, and those electronic records will not be proved ipso facto under the certificate that is usually given. Then Order 13A is the summary judgment. It's a very salutary provision and hardly ever used. Now, this summary judgment system has been taken from the US. In US, majority of the cases in commercial causes go for summary judgment. Summary judgment is one if you find that there is a cause and there is hardly any defense for it. So you take it up and you finish it up. That is the summary judgment. But otherwise, when there is a defense also, the summary judgment can be asked for by either of the parties, the plaintiff and the defendant, or the claimant and the respondent in arbitration. And that would be a judgment based on documentary evidence alone. So if there is an agreement, and in most of the cases, especially commercial causes, there is an agreement between the parties on which the suit is filed or the arbitration proceeds, and then there are correspondence. So you can take the document, interpret the document, and give a summary judgment without oral evidence. Not many suits are disposed of that way. Some suits on bank guarantees only have been disposed of, but there are so many other suits and so many arbitrations which may go that way, though we allow parties to lead whatever evidence that they want. Indeed, that has to be done. But we find at the end of it that the evidence has been completely redundant. It is only a kind of a copy of the pleading. And if that is so, then for commercial causes, that can be completely redacted and not taken into consideration. So that evidence goes completely, and a party who leads such evidence has delayed the commercial cause hearing and should be granted costs for that, is the statute today. Now, Order 15 is omitted. I don't know why it is omitted, because it was a very salutary order where if there is a case and there is no defense, then immediately the judgment has to be given on the admitted facts. Of course, that doesn't happen much in commercial causes. But under Order 15, Rule 3, it was that if there is any particular issue on which there can be a disposal, then only that issue can be taken up. Now, this is different from Order 14, Rule 2, which requires preliminary issues to be framed, which are only for a bar and for jurisdiction. So aside from the bar and jurisdiction also under Order 15 Rule 3, it can be done, and that can be done today only in non-commercial causes. I don't know why it can't be done in a commercial cause. For example, in arbitrations, we have many arbitrations where a claim is made, and that claim is very much sustainable. But along with that claim, there is a claim for damages, and the damages are far too remote and they cannot be granted. And even if evidence is led, ultimately damages are not granted. So, under Order 15, Rule 3, we could have dealt with and given the relief for a part of the claim, which is the real thing, and not the damages, because we grant interest. And when interest is granted for the entire period, usually other damages are not granted. Nevertheless, for commercial causes, Order 15 is omitted and Order 15A is put in. And that requires a case management hearing. Now, an excellent way in which a case management hearing can take place is that all parties file their pleadings. After the pleadings are filed, the adjudicator, be it the arbitrator or the court, reads up the pleadings, understands what the pleadings are, finds out the admitted facts in the pleadings, records those facts one by one, which has to be done for even admitted documents. Then he considers or she considers the admitted documents, marks the admitted documents, narrows down the issues, and then frames the issues. In a suit or an arbitration in which anybody would frame 36 issues, it would mean that there is no clarity of thought. Issues have to be only for material facts which are claimed by one party and denied by the other. So after taking in all the admitted facts, marking all the admitted documents, there would be 3 or 4 main issues on which an adjudication has to be done. That is for the case management hearing. In how many, aside from the fact of saying in how many weeks or months you can file your pleadings and finish it up, you can give inspection, all of those things which are in the amended CPC itself, the adjudicator would have to do this. Then time limits are granted, and time limits have to be made sacrosanct, because even if in some matters they say time limits are not mentioned and therefore the party failed, if that happens, as has happened in various other jurisdictions abroad, then everything gets settled, and then there is sort of more of justice quickly and disposals quickly with less delays. So, powers of the court. Now, when there is case management, the judge is in the driving seat. The judge understands and says how and when and what evidence can be led. And he would redact the evidence that is not required, or she would redact that evidence. So, those powers of the court are also for streamlining what would be ultimately in the adjudication process. Consequences of non-compliance are for the first time given, and what happens has to be seen when there is non-compliance, and those kind of orders for cause, for closing the evidence, for closing arbitrations, etc., have to be granted when enough has been enough. Now, Order 18. Order 18 is very interesting. Order 18, Rule 1, which is not within the Commercial Causes Act alone, but may apply, is that the right of hearing, who has the right to begin? And a party, usually it is the plaintiff or the claimant, of course, they would begin because there is so much that is denied. But if the defendant has admitted something, then the right of hearing, the right of first hearing belongs to the defendant. So in a very small illustration. For example, there is a suit of 1,000 rupees, and the plaintiff has said that I have gave it to a friend as a friendly loan. It's not a commercial cause, but I'm giving you this just to make it clear. And the defendant says, oh, what nonsense, I've already paid 500 rupees on such and such a day. Now that means that he has admitted receipt of 1,000 rupees, but he has paid 500 rupees, which the plaintiff has not shown. So the defendant has the right to begin, and he shows how and when he has paid the 500 rupees, and then the adjudication will be on the remaining 500 rupees. So then the defendant leads his evidence, the plaintiff may or may not lead evidence. Now, this is a very salutary provision. I would say this is really case management, and this is not what goes on in our courts. Because every time, without knowing, the adjudicator doesn't know what is in the pleadings because he has not read them. And the plaintiff just merrily begins and is cross examined. And then we find that ultimately a part of the claim was admitted, and therefore the defendant has to only show the other part and why that is not paid. Nevertheless, now in Order 18 Rule 2, there is an amendment. And that amendment for the commercial causes is for written arguments. So soon as the evidence is finished, we start the oral arguments. The oral arguments are very lengthy and go on, unlike in the West, where they give time limits. So now what they say is file the written arguments before you start the oral arguments. Now this is a very fine system because the lawyers have been working on that, on the argument aspect. There would be conferences, there would be notes made, there would be chronology of events and dates. All of these things. These things are kept in their pocket and they go on arguing. And after the oral arguments are over, they say, now give us time for written arguments. This is now turned over. And for 10 years, it has been turned over but is not followed. So, under Order 18 Rule 2, written arguments have to be given so that the adjudicator knows, oh, these are the points of written arguments. They can be ideally in bullet points today. And then you sort of, you explain the adjudicator orally what could be done. I mean, what could be those written arguments and why those judgments have been relied upon. What are the main paragraphs of the judgment that they are relying upon, etc., etc., so that it can be sort of, delays can be avoided and it can be streamlined. Then Order 18 Rule 4, which deals with cross-examinations and affidavit of evidence. Affidavit of evidence of all witnesses have to be brought in together. So you're going to examine 5 witnesses. You're going to examine yourself. You're going to examine your architect, your auditor, whatever, whatever. All that should come in at one time. That still doesn't come. And unless we have the commercial culture, we are not going to be able to say that we have created an image outside. There was once a seminar like this, and a Queen's Counsel, at that time it was a Queen's Counsel, now he would be the King's Counsel. He was appalled that one by one evidence is brought in and it takes months because that doesn't happen in London, he said. And even the recording of evidence, the way we do it, question, answer, in arbitrations, is completely wrong. A narrative always reads well. A narrative shows what were the questions. We are not concerned actually ultimately with the questions, we are concerned with the answers. And in paragraph wise, for a given topic, if an evidence is recorded, which so many arbitrators and judges do who are trial judges, that really shows what is those disputed facts and how they have been explained. So the Order 18 Rule 4, affidavits of all witnesses, and on that affidavit, one by one, the cross-examination. And that, of course, goes without saying that it should be day to day, at least 2, 3, 4 days together for one matter makes it even better. Now, Order 19, Rule 4, court to control the evidence and exclude evidence. So therefore, under Section 10, even in arbitration, the adjudicator has to control the evidence. Now, there are so many times where a document is proved by the witness who is the author of the document. And then all sorts of questions are asked. What is in paragraph 2? What is in paragraph 4? It doesn't make sense, and that cannot be accepted even in arbitrations and must be redacted, must be controlled and not allowed. Or if it is led, it has to be excluded when the appreciation of evidence takes place. Then Order 19, Rule 5, the court may redact or reject evidence which is inadmissible. So if evidence is actually submissions on law and facts and all of those things must go, an affidavit of evidence is only a statement of disputed material facts. There are a lot of times in arbitrations that for a very simple application, I want 2 weeks' time to file an affidavit in reply. It is completely redundant. It is not required. It should not be allowed and should not. We allow it at times and we ignore it thereafter because what is argued is really important. It is sometimes only a question of law and it doesn't require an affidavit, much less the affidavit of a client who doesn't even know what is writing there and says that it is what I know. So these things are inadmissible in commercial causes, in either adjudication or in arbitration. Then Order 19, Rule 6, the affidavit of evidence should be in a prescribed form. And that prescribed form is now given in the Commercial Causes Act. But affidavits of evidence are not in that form. They write about all sorts of ways in which a document, which is even an admitted document and marked as an admitted document, is sought to be proved in an affidavit. It has to be completely ignored. It doesn't show good advocacy actually. Order 20, Rule 1 is judgment within 90 days, and therefore I would say even awards within 90 days. And 90 days is also quite a long time because if matters are taken up and then immediately worked on, it doesn't require 90 days. Now the CPC and the CCA, they are the law as an instrument of social change. And when we have that culture change, we would have these things. And to have that, what do we require? One, case management hearing. Two, denials with reasons. Very important, oft neglected. Summary judgment. Pre-litigation mediation. Accountability. Accountability of clients, auditors, advocates, everyone. Written statement within 120 days. All documents in affidavit of documents. All affidavits of all witnesses together. And then judgment within 90 days. This is how I would concise the law of commercial causes, which is really a very fine law, only if we all respect it. Now, the CCA and the Arbitration Act, which I told you about, which are those provisions in arbitrations which would be applied for those commercial causes which come up in arbitrations. The rules of procedure by parties and the arbitrator under Section 19. Time limits under Section 23 for SOC, SOD, set off and reply to the counterclaim. Section 23. Then oral and documentary evidence under Section 24. All that evidence which has to be given. Then oral hearings day to day or costs. So if parties do not come, then costs can be granted under Section 24. We would rather not grant costs, but rather finish up the matters because it augurs well for both the arbitrator and the advocates. Time limits for the award. Now, this award cannot be granted within the time period. Actually, the time period is very fair. In many, many cases where parties, lawyers, and arbitrators really work well, it goes off within 6, 7, 8, 9 months. But if not, then under Section 29A, it can be extended. And that extension is by the High Court. So it is not an extension for the asking. It is extension after application of mind and after finding out why more is required, how much more would be required. No, not as much as what you asked for, but this much, and it has to be completed within that time. Because as I said, the obligation to grant under this section implicit has the power to refuse under this section, which doesn't have to be given in a legislation. Very well. Then fast track procedure under Section 29B. So if parties say that we don't want to lead any oral evidence, but we want a judgment quickly or an award quickly, then under the Arbitration Act, Section 29B, fast track procedure is without giving reasons, you give the award on the documents which are on record. Then interest and costs. Under Section 31 and 31A, interest can be granted. A very salutary provision under this Act, right from 2015 amendment, is that interest not only of the commercial interest that the banks grant, but 2% more than what the banks would grant. And that kind of interest, unless, of course, the interest is determined by the arbitrator, as, of course, would be by the judges in an adjudication. So if interest is determined, say 18%, which is generally very fair and a commercial rate of interest, it can be granted. Otherwise, whatever is the commercial rate at that time, plus 2%. Very interesting. And costs are actual costs, costs of arbitration, fees of the arbitrator, fees of getting all the witnesses, having the venues, fees of the lawyers, everything can be settled upon the party who has either delayed wrongly and succeeded also, or has failed. Then finality of awards. Under Section 35, awards are final, except, of course, those grounds which are laid out, the patent irregularity, the corruption, the fraud, etc., where even without deposit of amounts, under Section 34, awards can be set aside. Appeals from orders are under Section 16 and 17, which are enumerated under Section 37 of the Arbitration Act. And the entire part 3, which is oft neglected, is conciliation. Now, under the Mediation Act of 2023, this conciliation has to proceed as mediation proceeds under the Mediation Act. But under Section 30, we have settlement. So if parties are amenable, and if the arbitrator feels, just as in a suit, if then the court feels, the parties can negotiate and settle that dispute, or the parties can refer the dispute itself for conciliation, which will be as per mediation and then an agreement. That is under Part 3 of the Arbitration Act. Now, I would say that taking all this, just as we saw the features of the CCA, the features in arbitration, the ideal procedure would be a 7-step formula. And I would say it is AAMIEAA. These are the things which have to be followed in arbitration, though CPC and Evidence Act are not applicable and need not be followed. But the fundamentals of CPC and Evidence Act have to be followed, and the actual rules under the CPC in the amendment to Section 13 of the Arbitration Act will have to be followed. So the 7-step formula, AAMIEAA, would be A for address. The address is if there is an arbitration without any interim application, you ask the parties, by and large, what is this dispute that you are talking about? Okay, so you understand the dispute, you read up the pleadings, and then you do the various other things which I'll tell you. That is for the arbitrators. If there is an interim application, this can be avoided because interim application, everything is known to both the parties, argued by both the parties, and understood by the court or the arbitrator threadbare. So then that would be the address. Then the next A is the admissions. Very important because there is now a specific provision for admissions and denials and for passing orders on admissions. And what could be the orders on admissions? You record those admissions, and if there are documents, then you take those documents on record. These are the two main facts. So M for AAMIEAA would be marking of admitted documents. And there are many documents in most of the commercial causes which are admitted documents. They are for understanding the interpretation or making of the interpretation of those documents, understanding how the clients have dealt with those admitted documents, which are contracts, etc., or the correspondence which has ensued, which would also show some admissions, etc., and which can be, of course, appreciated when you appreciate the evidence of the parties. Then comes the framing of issues. So if admissions and denials are understood and recorded, documents are marked, the procedure becomes very clear. There is no kind of confusion, and with a lot of clarity, you would know what are the few remaining important issues which are disputed facts and which will have to be adjudicated upon. So the issues are narrowed down. Then comes E. E is for evidence, oral and documentary evidence. Oral evidence may not be there. Oral evidence is not the repetition of what is in the pleadings, but it is allowed to be led because it is insisted upon being led, and then we know that it has been bad advocacy. It is absolutely of no use. The real oral evidence would be of the independent witnesses. Let us say, for example, the party says a particular thing. This is what has happened. But the auditor says something entirely different, that in forensic audit, this has not come up, for example. What the party says is of no use. If there is a documentary evidence, if there is a document giving the parties a particular share, and if the party says, no, there is a bigger share for me, it doesn't make sense because the documentary evidence will override the oral evidence. So that is it. Documentary evidence in a commercial cause is extremely important and must be read cover to cover by the adjudicator and must be understood and shown properly by the lawyers. Then written and oral arguments. I won't say now oral and written arguments. Formerly, we used to say oral arguments and written arguments. But in commercial causes, first are the written arguments if the advocates have been very well prepared and follow the law. If not, then we allow the oral arguments and then say, okay, give us only bullet points of what you have argued. But that is not stricto sensu the law for commercial causes. And then the award. The award should be soon thereafter. I don't think 90 days are required. I've never taken 90 days for an award or for a judgment. But that much time is given because in some few matters that much time would be required. Now, what we understand is that this is for the courts, this is for the arbitrations in commercial causes. But there is also mediation, and mediation is a very fast approaching court culture in many good jurisdictions. It may not be there in most of the jurisdictions in India. As I understand, in Delhi and Bangalore, it's going on very well. It's not going on so well in Bombay, I may say. But ARB and Mead and ARB together form a very good partnership. So that is really the alternative dispute resolution. Arbitration followed by mediation. Now, in arbitration, we understand what are the pleadings. We know what are the admitted facts and documents. The parties have argued, and we understand quite often that a business relationship can be better kept if we don't give an award or if we don't give a judgment. That is when the beauty of mediation comes up. And therefore, when we negotiate, we facilitate the negotiation. And then there is an arbitration, a mediation or a conciliation. It works best, and the award need not be given, or even if it is ready, it will not be pronounced. Same would happen in a commercial cause where mediation is thought to be a right remedy. Now, mediation actually does not require in adjudication consent of both the parties. But we want consent of both the parties because there is no point really in making a party go when a party goes and says, I'm not going to be amenable to mediation. But that is how mediation has failed, and that is a very bad thing because mediations are now being taken up by parties other than lawyers. So lawyers would be bypassed, mediators would take hold. There are n number of mediation trainings, even a full-time 2-year master's degree course in mediation in various universities in access to justice, etc. Mediation, and if not successful, the mediator to give an award is meet art. So then mediator becomes an arbitrator. But that has to be agreed by the parties so that then there is no dispute. So if he allows the parties to mediate, the parties can be raising their own options. If the parties are not able to do so, then the mediator by now knows what are the real facts, etc., and would give an award. Settlement is within arbitration under Section 30, as I just said, and conciliation is in Part 3, Section 61 to 80. So ARB made MEDAB and only conciliation also are various ways in which business disputes can be settled. It is said that not it is said, it is told that in Bangalore, the High Court Mediation Center has agreed and partnered with the BCIC, the Bangalore Chamber of Industry and Commerce. It has got so many business people. They now want to go to lawyers who can negotiate on their behalf, facilitate negotiations, and settle their disputes on their behalf. And they don't want adjudication, they don't want arbitration. So this culture which is coming up is sort of a very new culture in commercial causes. Then comes the understanding of CCA and the Mediation Act. Pre-litigation mediation in commercial disputes is under Section 12A, and under Section 5 of the Mediation Act, these commercial causes can be mediated so that business relationships can remain. And so often we find that these are family partnerships which land up as commercial causes in arbitrations. And family relationships as well as business relationships can be very well maintained if parties understand and come to some conclusion by creating some options which we will not know in adjudication or arbitration, because only what are the facts on record which can be seen. But in mediation, you can see so many other things which are not facts on record. And therefore, arbitration and after that mediation also is fine, because when an arbitration takes place first and an award is made, it is always on the record of the proceedings. And then for mediation, there are various other things which come up, which cannot come up in arbitration if that mediation fails. So then there is no dispute really about the award having some things which are not on record. This is my personal experience. Then time limit in mediation. Even in mediations now, there are time limits given. And the same time limits as in the CPC, as in the Arbitration Act. 120 days for the mediation, if not 60 more days under Section 18. Then challenge to agreements. When there are mediation agreements and they have to be challenged, then it must be within 90 plus 90 days under Section 28. It is analogous to Section 34 of the Arbitration Act. So after that, the agreements become sacrosanct, they become a decree passed by the court, and they can be enforced. Conciliation under the Arbitration Act is now to be taken as mediation under the 6th schedule. Okay. So we have, you can say, arbitration and mediation, the CCA and the Arbitration Act, the CCA and the Mediation Act. Now this, friends, is case management. And when case management culture began in England, what was it? It was practitioners and judges becoming better at what they do, achieving the same end with less resources and in less time. This is what Lord Justice Wolfe, the Master of Rolls at that time, had said. And that is the Lord Wolfe report, much of which is accepted by us by way of this kind of amendments for case management in commercial causes. Now, case management is for what? It is for improving efficiency, reducing delays, and cutting costs. Or, of course, granting more costs if costs could not be cut by one party. So, aspects of case management in the UK may be understood. It is there from 1997 in the Criminal Procedure Act in England. Length of time for litigation. Now we have length of time for filing all of the pleadings. Fast track and multi-track. Now we have summary judgments, which are there, of course, summary procedure even in England, and multi-track, where you have got not only the fast track arbitration, but a proper arbitration with oral and documentary evidence. Fixed timetable. So we have now fixed timetable for filing of pleadings, fixed timetable also for completing arbitrations and suits. Exchanging witness statements. So all witness statements come together and then they are given to the other party. So the party know what is the periphery of the evidence which will be granted and get prepared for his evidence. We don't do that much here. Exchanging witness statements are one by one. Video recording of evidence. Now, whenever an evidence is taken, if it is video recorded, there need not be, and if it is also audio recorded, there need not be a kind of writing down, but there is written oral evidence, which is taken down by the adjudicator. Queen's Counsel was aghast that we still have this in all of these matters because it is not so in England and America. It is just recorded, and only when there is an objection, whether the objection is overruled or sustained, is shown by the adjudicator. Interest and costs, as I told you, is now very well settled. Interest, which is higher than the commercial interest, costs which are actual. Summary procedure for all suits below £10,000 is in England, and that summary procedure is without recording evidence. ADR is a part of the case management in England and training and education, which we now have in the Commercial Causes Act. Then Lord Wolf report, therefore, is for procedural simplicity and for control by the adjudicator of the proceedings that go on. So the adjudicator is not only a scribe and doesn't know what evidence is being led and the evidence goes on and on. That is now not the court culture or the arbitration culture. Lord Wolf report is therefore applicable and has been applied in given ways. Amendment of the CPC and the High Court rules, written statement and affidavit in reply, examination in chief of all the witnesses, summary trials, civil and criminal judges are separate, and ADR for commercial cases. Then the CM strategy, the case management strategy, as one can see, endeavor to get disposed of and complete all the proceedings filed once at a time when all the parties are represented and heard on merits, and endeavor to get disposed of and complete the main proceeding at the first available opportunity when all parties are represented and heard on merits. Now, this is to avoid all of those needless technical objections and applications. One unique trial practice that I may tell you of a long forgotten judge, Sir Norman MacLeod of the Bombay High Court. He was a judge from 1919 to 1926, more than a century ago. As a trial judge, he would ask the plaintiff, and this is written in a book from where I got it, he would ask the plaintiff what is stated in the plaint is correct. The plaintiff would say, yes, judge, whatever is correct. So he would ask the counsel to cross-examine the plaintiff. In some cases, he dispensed with the addresses and delivered his judgment. And P.B. Vacha in his book has recounted that practice and said that on most of the occasions, the judge was right. US precedent practice. It's nice to know in different jurisdictions what happens. There is restatement of the law, which is a very salutary sound provision. So every 10 to 15 years on every topic, there is a restatement of the law. Then the case law of earlier times need not be cited. So only the later judgments can be cited, and then we don't have kind of 15 judgments on the same point being given by a given act. And then there is what is called rocket docket in America, which is fast track litigation, summary trials. So that is to ram the frivolous cases, they say, through discovery and get them to trial. And this interesting provision was stated by John Grisham in his book, The Litigators. So friends, I would conclude by saying there's a joy in doing something as well as you could and better than what you thought you could, as said by J.R.D. Tata. Thank you. Good day.
मेरे को कोट करा दें. Good evening, ma'am. Those who are actually waiting for the session after there were certain issues, but you have actually taken away so many points. People will remember those 7 short, what we say that you have to remember it by the similes. People will definitely remember. And it will be also a perspective on the commercial perspective, how to fast track the sessions and discussions. I'm reminded that once we did one session in respect of court management by you, a lot of takes away on that aspect. And thank you, ma'am, for sparing the time on a Sunday evening. We are so glad and thankful to you. Namaskar.
Thank you.